that she would arrive. And then
or counsel would be there. Actually,
yes.
there were a lot of media friends of ours messaging me no, kung pupunta yung legal team. But as you know, in the earlier statements or pronouncement at least of the Committee on Justice, ang sabi kasi is counsel is the presence of counsel is only to assist the client. So kung wala yung client, we didn't think that we had any right to participate anyway. So hindi talaga kami pumunta. No? But just to put things in context, we had a letter. We wrote a letter to the Committee on Justice, addressed of course to the Honorable Chairperson. We submitted the letter the day before the hearing kasi nga ayaw naman namin na the day itself. No? So we submitted it after, was after discussing the matter, of course, with our client, the Vice President. And we decided to submit that letter. And in that letter, we indicated the reasons why. Primarily, kasi hindi gusto natin i-simplify yung concept. Primarily, we stated our fundamental objection to the conduct of the proceedings. No? Anong ibig sabihin nun? Nilagay namin doon na sa aming pananaw, again, with all due respect, of course, to the committee, pero sa aming pananaw, walang jurisdiction ang committee to conduct a trial, whether a mini trial or a full-blown trial. No? Because under the Constitution, very clear naman, under Article 11, no? Na yung power to initiate impeachment proceedings belongs to the House. That's admitted. But the power to try impeachment cases is exclusively vested upon the Senate. So sa amin, ang pananaw namin is itong nangyayari ngayon na yung term na mini trial, hindi naman sa amin galing yan. No? But itong nangyayari na sa tingin din namin ay nagiging mini trial na rin talaga. Ito ang sanhi kung bakit meron kaming objection at kung bakit the Vice President did not attend proceedings yesterday.
What, for the sake of our audience, what are the earmarks or why would you consider it as they were conducting a trial?
Well, for us, if we were to determine probable cause or at least determine kung ito ay pagbobotohan na, gagawa na ng committee report at iaakyat na sa plenary, they are confined only to the evaluation of the complaints and their attachments. Yan yung mga napag-usapan na rin natin the last time, no? That you are confined to the four corners of the complaints, the allegations therein, and the attachments. And from there, you should be able to determine if there's probable cause for impeachment. Ang nangyari kasi ngayon, they're going beyond. No? Doon sa allegations, evidence attached, they're now issuing subpoenas left and right for certain documents. And so we feel na trial na to, and then you will be inviting witnesses wherein the members of the Committee on Justice will have the right to examine and cross-examine, whereas the respondent would not have that. No? So sa amin, this goes beyond determination of probable cause. This is, as they say, a mini trial, which we feel belongs to the Senate pagdating ng trial.
But doesn't the House of Representatives in its impeachment rules actually provide for the power to issue subpoena and to call witnesses as part of the process of making a report that they will submit to the plenary within 60 days. So, and in past impeachments, nagkakaroon naman talaga ng witnesses na tinatawag. And yes, the members of the Committee on Justice do ask questions of these witnesses. Kasi I think ang explanation nila dyan is similar to a preliminary investigation, di ba, in criminal proceedings. There is actually a hearing and there is actually the opportunity for, in that particular case, of investigating prosecutor to ask clarificatory questions. So isn't that similar to what the House is trying to do here?
We admit that under the rules, there is a provision there that provides them the power for to issue compulsory processes. But as you said, Attorney Barry, pagdating sa preliminary investigation, the nature is clarificatory. No? So kung walang naka-attach na ebidensya doon sa complaint, what now gives in a preliminary investigation, the prosecutor to now search for other pieces of evidence that aren't included there because it's up to the complainants to build their case, hindi ba?
In the 2024 rules of the DOJ, di ba, merong case build-up.
Yes,
but that's actually integrated in the rules. So, in essence, doesn't that allow yung prosecutor to ask for additional evidence in order to meet yung standard of...
Actually, in the 2024 rules, no, may tatlo lang pwedeng gawin yung prosecutor, if I'm not mistaken. It's to determine kung pwede nang i-dismiss na lang yung kaso.
Yes.
To titingnan kung ripe na to submit the matter for resolution, or third, to ask the complainants, no, kung clarificatory questions and maybe documents. But hindi sila mismo yung nagpapasabina, hindi ba?
Yes.
And in this case, kung makikita mo yung mga sinasabina, wala nga sa allegations na ng complaint paminsan. So sa atin, tinitingnan natin na this goes beyond. At least that's our position. No? This goes beyond the power to initiate impeachment complaints. This already is encroaching upon trial or mini-trial, and that is exclusively with the Senate. Yan ang aming position.
So ang sinasabi nyo, your position is essentially the House should confine itself to looking at what evidence is already attached to the complaints.
Oo, but of course, clarificatory, wala namang problema. Kung meron silang witnesses na nandun, let's say may affidavit, gusto nilang patawag, gusto nilang mag-clarify, nagagawa naman yan kahit sa preliminary investigation, hindi ba? Pero kung wala namang mga affidavits ng witnesses, for example, ang tanong natin dito is how far will this go? Diba? Sino pa ang papatawag na hindi naman kasama doon sa mga affidavits na na-attach doon sa complaint? And kung mangyayari yun, para na tayong nag-trial without the right of the defense to cross-examine the witnesses.
So, given yung basically difference in perspective between the defense team and the Committee on Justice, do you plan to actually challenge the proceedings before the Supreme Court? Kasi that seems the only logical next step here. If you're not going to participate and you think that they are acting ultra vires, diba? They're going beyond what the Constitution actually empowers them to do, then that seems like the logical next step. Is that should we be expecting
That's
that?
definitely a possibility. Ayoko pang magsabi ng anything categorical at this point, but that's definitely a possibility because, as you said, that is the logical next step. There are several remedies. We are actually considering all remedies possible pa. Kaya nga, sinimulan muna natin sa committee. No? Hindi tayo yung biglang umakyat. Inilahad muna natin sa committee yung ating posisyon. And based on the discussions yesterday, I think may mga hindi nagustuhan yung aming letter, and we really regret that. No? We really regret that. That was not the intention. The intention, because as lawyers of Vice President, was to protect her rights, no? And her interests. So, syempre, it was incumbent upon us when we see some infirmity, it was incumbent upon us to at least put the committee on notice na ito yung posisyon namin.
What was in the letter that they disagreed with, or
that actually provoked such a strong response?
I know, and I really regret that it did so. No? That was not the intention. The intention was really just to lay down our position, which, as I've said, really centered on the lack of jurisdiction of the Committee on Justice to conduct a trial, whether mini or full-blown. Yun lang talaga. We in-enumerate namin yung mga provisions sa ating saligang batas, kung ano ang initiation at kung nasaan ang power to try impeachment cases, and that is with the Senate.
And at some point, Chairman Luistro manifested herself that what she called a mini trial is actually simply a process for clarification. So she underscored that, but the committee voted anyway for the compulsory processes. And yun nga, it still drew Congressman Rodriguez's strong reaction to the letter. So, but if it was simply an explanation of your side, was there anything in particular, like the wording that
why did they take such
reacted to?
offense? Kasi
Perhaps it was really I don't want to speculate on exactly what triggered that. No. And again, we really regret that that's how they felt. That really was not the intention. As I have time and time again said that we respect the opinions of our lawmakers and the members of the committee, even if the opinions are adverse to our position. No? But I think perhaps it's when we stated that they had no jurisdiction to do this. Siguro medyo may pagka-confrontational yung dating. But again, that wasn't the intention. The intention was really to lay down what we feel is stated in the Constitution. At sa amin, that was a fundamental objection kasi. No, na for us, you cannot proceed this way. Kung sa tingin nyo, number one, meron nang nagkaroon na ng sufficiency in form, sufficiency in substance, sufficiency in grounds. So sa amin, ang posisyon talaga namin is while you have leeway for clarificatory questions and holding a hearing for such, bakit hindi na lang from there mag-determine na kung may probable cause?
So to be clear, the jurisdiction is not the power of the House to conduct impeachment proceedings in the first place.
No,
It's you should not be calling additional witnesses and asking for additional evidence beyond what is already provided for in the committee. Dapat confine yourself to clarificatory questions. Yun yung position.
Yes, because again, it's the burden of the complainants to prove or to
build their
show
case,
at least
yes,
that they have a strong case, no, na may probable cause. But again, thank you for helping me with that, Attorney Barry. No, we are not questioning the power of the House to initiate impeachment proceedings.
yes.
I think medyo ano na tayo, nagkakalabuan na tayo kung pati yan kinokontest.
Hindi, kasi
That's not true.
yung feeling ko may confused kasing tao
Yes,
dahil
oo.
jurisdiction yung ginagamit. Diba?
So when we say jurisdiction, it's not the jurisdiction of the House to initiate. It's a jurisdiction of the House to try cases because we feel that that's what's happening now. Parang you're trying cases na sa pananaw namin. And to us, that exclusively belongs to the Senate namin. And to us, that exclusively belongs to the Senate.
Kumaga, they're jumping the gun. What should be something that the Senate should be doing, ginagawa na nila dito sa level
Yes,
of the
and it
committee.
might be duplicitous in a way because magkakatrial din naman tayo sa Senate kung talagang aakyat to. Plus, in this case, paano ang respondent dito, di ba? Although, yesterday, I must admit, si Congressman Chel Jokno, whom I also have the utmost respect for, I think proposed amendments to the rule na pwede nang magtanong ang council through the chair. No?
So, magkasabit ng...
Oo. I just don't know how it will be operationalized if that really happens because na-approve kasi yung amendment na yun as far as I know. No? Pero paano yun? Kasi alam nyo naman sa cross-examination, it's really the council that does that.
Yes.
No?
Yeah.
And you have to be fast on your feet. Diba?
Exactly.
You have to think on your feet.
Hindi, tsaka, depending on yung answer, your next question might change.
Yes,
Diba yun?
yes. So how do we now do that? Diba? So again, I think yung mga ganitong bagay, it's best done sa isang trial, diba?
Yes,
Which well, constitutionally belongs to the Senate.
Okay.
But don't you think that, yun nga it's hard to police the portion where they're asking clarificatory questions? At what point does it become like a direct
Inquisitorial.
and then, yes. But right now, that's how it's set up. It's an inquisitorial format because prosecutor's office is also inquisitorial in
Tama.
nature.
Yes, and if I think I brought this up the last time I was here. I looked back, no, it was the same issue that the lawyers of the Honorable former Chief Justice Sereno faced during the committee stage.
Yes,
I remember I saw an interview of, I hope he doesn't mind me mentioning his name, but Attorney Alex Poblador, also having the same concerns that when they were there, they could not really participate kasi I think they were given an SPA, but they could not really participate. So, parang I find ourselves in the same quandary, no? Paano to? Kasi pag nag-represent ng witness, they will expectedly say things against the Vice President. How do we now defend the rights of our client pagdating dito? And that's the purpose of trial, actually, so that things can be said and we have the opportunity to rebut. But now, how